Hello, and welcome to Politics for the People. I'm your host, Michael Striano. Thanks for listening and joining in the conversation. You can find links to our Patreon and Instagram in the show notes and sign up for our weekly newsletter. Don't forget to subscribe if you haven't and leave a review wherever you get your podcasts to help others find the show. Okay, let's get to it. Our topic this week, the Supreme Court. This is part 2, so if you missed part 1 last week, stop here, go back, and give it a listen. For a quick recap, we discussed what the court is and how it functions. We established it exists to protect our rights as laid out in the Constitution, but also talked about the process of how the court protects those rights. For part 2, we'll take a look at how the justices are appointed to serve on the Supreme Court, and more importantly, how does this affect our everyday lives? So, how does someone get on the Supreme Court? The Constitution doesn't really require any qualifications. It pretty much just says they have to exhibit good behavior, without explaining what even that means. While the Constitution does not give direction on who may be appointed, it does tell us how they are appointed. First, the President nominates an individual. Since Supreme Court justices serve lifetime appointments, this is a rare and important decision. White Houses often have lists curated in advance, should a vacancy open up on the court by a justice's death or retirement. These lists consist of candidates who are typically judges or lawyers with impressive or notable records. The list is cut down through several rounds of vetting until a lone name stands and is formally nominated. After the formal nomination, the Senate Judiciary Committee reviews and vets the candidate, asking their own questions, and issues a report on the candidate to the full Senate. The Senate then takes a vote to talk about the issue, called a cloture vote, and the full Senate begins their debate. This is the time in the process when it used to be possible for a filibuster, or an intentional delay by the minority party, to occur. The ability to filibuster appointments to the federal judiciary was eliminated in 2017, but I wanted to mention this is when it used to happen, during the cloture vote. We're going to talk about the filibuster in a future episode, so make sure you're subscribed so you don't miss it. Following the cloture vote, the Senate debate process takes as long or as short as is deemed necessary, although the process has lengthened over our history. Originally lasting about 45 days, the process now averages closer to 75. However long it takes, eventually the Senate votes to confirm or reject the nominee. Technically, there is another way a justice can be appointed to the Supreme Court, called a recess appointment. Here, the president appoints someone to the court temporarily because the Senate isn't in session to vote on the nominee. The appointed justice's term ends with the next Senate session, but otherwise, the process is the same. The Senate still questions the nominee and holds a debate, culminating in a vote to confirm or reject. This method still exists, but hasn't been used since 1960 and isn't likely to be used again. It is also possible, although it has never happened, for a justice to be removed by the Supreme Court by impeachment, just like with a president. Only one justice has ever been impeached, Samuel Chase, in 1804. The House impeached Chase, arguing that his severe partisanship amounted to a high crime and misdemeanor as laid out in the Constitution. The Senate trial was overseen by Vice President Aaron Burr, who, at the time, was wanted in New Jersey for the murder of Alexander Hamilton. Chase was acquitted by the Senate, but the process was perceived as having been so bad for the country. President Jefferson called the impeachment of justices a farce which will not be tried again. And so far he's been right. So, how does the Supreme Court affect our everyday lives? I know this episode has been a bit dense compared with past episodes, but you can't talk about the Supreme Court without talking about theoretical ideas. The real purpose of the court is to protect our rights as Americans, guaranteed in our Constitution and its amendments. Even if Congress and the President pass and sign a law infringing on our rights, the judiciary acts as a safeguard of our liberties and would declare such a law unconstitutional. A nonpartisan judiciary is essential to our government, and we've seen recently that just because a judge is appointed in partisanship doesn't mean that will affect their decisions on the bench. Much to the dismay of President Trump, both of his appointments to the Supreme Court have already ruled against him in their brief time. Now, this isn't to say the Supreme Court has always been on the right side of history. One of the most infamous decisions planted them firmly on the wrong side of slavery. Dred Scott v. Sandford. In 1834, a white man had brought his slave, Dred Scott, with him on a trip lasting 4 years from their home in Missouri, a slave state, to Illinois, a free state. The two returned home, and after his owner's death, Scott sued the widow for his freedom, alleging his time in a state where slavery was illegal had made him a free man. At first, a Missouri court declared him free, but the widow appealed. After passing ownership of Scott to her brother in New York, the case made its way to the Supreme Court, who didn't just rule against Scott, but decided by a margin of 7-2 that black Americans could not be American citizens, Congress could not free slaves or outlaw slavery, and that slaves were property protected by the Fifth Amendment. The 1857 decision is still a stain on the court's record. Perhaps the only positive about the Dred Scott case came in 1860, when Abraham Lincoln won in part by campaigning on the case. In his inaugural address, Lincoln warned that important issues affecting all people should not be left to the Supreme Court with no review, setting up the idea that an amendment to the Constitution would be necessary to finally defeat slavery. In just the few cases I've mentioned, it's already clear to see how Supreme Court rulings are not a replacement for legislation or constitutional amendments, nor are they meant to be. Decisions by the court are intended to interpret and determine the validity of laws, not create new ones. This brings us to the last case I wanted to discuss, Roe v. Wade. Now, as regular listeners of the podcast know, I'm not going to get into partisan ideas or argue one side over the other here. I'm just going to present the facts of the case as they relate to our discussion. A woman used the pseudonym Jane Roe to sue the district attorney of Dallas County, Texas, Henry Wade, over a law prohibiting abortion except to save the mother's life. Roe asserted the law was overly vague and infringed upon women's First, Fourth, Fifth, Ninth, and 14th Amendment rights. The court agreed to hear her case mostly based on the Due Process Clause in the 14th Amendment, which guarantees a right to privacy. Weighing this against the potentiality for human life, the court decided that there must be a balance between these interests. As the fetus becomes more viable, the right to an abortion lessens. The court divided a pregnancy by trimesters, and ruled abortions could only be limited in the second trimester and prohibited in the third, except if the health of the mother was endangered. This 7-2 decision was not intended to be the end of the conversation, but was merely an answer to a question until legislation or an amendment was passed. In the decades since this decision in 1973, this tenuous hold on a woman's right to privacy over her own body has been assaulted and attacked in every way conceivable by anti-abortion advocates, but the ruling has stood. Most Supreme Court decisions are based on precedent. Unless a very strong argument can be made to change an opinion, as we saw with Brown, the court follows the lead of previous rulings. Following previous decisions is a powerful idea in the legal community, but precedent still doesn't outweigh legislation or amendments and is not meant to be used as a governing tool. We talked about the system of checks and balances, and since the Supreme Court is just a part of that system, if too much power and emphasis is being placed on the court, that probably means the other parts aren't working properly. In times of hyperpartisanship, historically the court has leaned even harder on precedent, because the legislative and executive branches stop governing effectively. We seem to be in one of those times right now. In times like these, who is serving is more important than ever, and who serves is determined by the President and the Senate. Your only say in the matter is your vote. Since you can't decide for yourself who goes on the bench, make sure you trust the people putting them there by exercising your right to vote. The late Justice Ginsburg was confirmed by a vote of 96-3. Use your voice, vote, and let's try to get things working again. Let's get back to a time when anything could pass Congress with 96% of the vote, especially a brilliant woman like RBG. Thanks for listening, and a special thanks to our patrons on Patreon for your help in making this happen, and all those who have left us a review. Be sure to check out the show notes, where you can sign up for our weekly newsletter and follow us on Instagram at Politics for the People Podcast. Want to help shape the conversation, have a say in episode topics, and get exclusive content, including early access to episodes and live conversations with me? Check the show notes, head on over to our Patreon page, and subscribe for as little as $3. We'll see you Wednesday with our newsletter, and Friday with a brand new episode. Take care.